The Presidential Election Petitions Court resumed on Monday after a week's break for INEC to begin its defense of the petition by the Labour Party over the conduct and outcome of the 2023 presidential election. But the Commission could not call any of its witnesses, forcing the court into an abrupt adjournment. This is the first time INEC is opening its defense at the court. The defense to be put forward is particularly significant because it conducted the elections that is the subject of litigation. Interestingly, it had opposed almost all the documents, including certified copies of the election materials, while the petitioners, that is the Labour Party and the PDP, and their presidential candidates had obtained from it and tendered before closing their case. But on the day it is supposed to open its defense in the case of the Labour Party, it all ended in a climax leading to an abrupt adjournment of the petition of the Labour Party, reasons being that INEC could not present any of its scheduled witnesses for the day. Day 2 of the proceeding, the Independent National Electoral Commission INEC was finally able to present its first and only witness against the petition of Peter Obi and the Labour Party. The witness, Dr. Lawrence Bayode, was the same person it presented in the case of the PDP on Monday. Bayode, an ICT expert who adopted his deposition before the court, was led in evidence-in-chief by the INEC counsel, Abubakar Mahmood. He repeated the same things he said while testifying in the PDP matter, citing a cloud trail log while making reference to the glitches during upload of results. Under what was a friendly cross-examination by counsel for the APC, Lateef Fagbemi, and that of Tinubu and Shettima, Wale Olanipekun, the witness admitted to the fact that the glitches did not affect the upload of the results, and that where the results downloaded from IRF isn't clear, physical results can be obtained. During cross-examination by the counsel for Labour Party, Patrick Ikweto, the witness admitted that there was a performance and functionality test done on February 4 to identify the vulnerability of the server that INEC worked with. He explained further that the essence of the performance test, which was done at the pre-production stage, was to assess how the system would behave under heavy usage, and testing was done at the back end of the server to ensure the system is well secured. The witness, however, admits that the server was not vulnerable to stress.
The Form EC8A was meant to be what is on the IRF, but we have Forms EC8As, we have IRF copies certified by INEC, which are completely blurred, unreadable, contains strange pictures, images. Indeed, the IC director was given a copy or copies of these blurred Forms EC8As, presumably, and was asked to tell the court how many scores that were written on those copies. If you were in the court, you would have seen his difficulty because nothing was written on those documents. So one wonders, on what basis did INEC collect the result? On what basis did you announce a result when you have results of the election given by you that are not clear, they're not readable, that are indeed blurred images, blurred pictures? What are you declaring? What are you collecting?
Day 3 of the proceedings, the Presidential Election Petition Court admitted in evidence the membership list of the Labour Party for Anambra State, showing that the Labour Party presidential candidate, Peter Obi, was not a member of the party at the time the register was submitted to INEC. The list was submitted along with a letter of membership registration sent to INEC and dated February 25, 2022. In opposing Peter Obi's petition, Tinubu and Shettima are contesting Obi's legal status to file the petition, arguing that he was not a candidate in the first place, having not been included in the list of members of the party in the state. The document formed part of the 18 documents tendered by Tinubu and Shettima and admitted by the court in defense of the petition by Labour Party and Peter Obi. Tinubu also presented his only witness, Senator Okpeyemi Bamidele, who testified on the alleged criminal forfeiture case against Tinubu in the U.S. court. Bamidele, who told the court that he was licensed to practice law in New York and is a member of the American Bar Association, said that the forfeiture was a civil one and not criminal. Under cross-examination, by Labour Party's lead counsel Levi Uzoku, it was noted that Bamidele did not submit any identification to show that he was licensed to practice in the state, New York. But he insisted that his membership of the New York Bar grants him license to practice federal law across the US. The hearing brings a conclusion the evidence stage of the petition of the Labour Party and Peter Obi, after the APC, which was the next in line to present its defense, said it will rely on the witness of Tinubu and Shetima. The next stage of hearing is the adoption of addresses. The court has directed the respondents to file their addresses within 10 days, while the petitioners have 7 days to reply. 5 days have been given to the respondents if they wish to file a reply on point of law, after which the court will appoint a date for adoption of the addresses.
I'm sure that you know that INEC called one witness, closed their case. Second and third respondents called one, closed their case. APC had no courage to call any, and they closed their case. The witness for the second and third, the only thing I can say, I encourage you people, look for his deposition, place it side by side with the cross-examination. You make up your minds and find out whether the two of them are consistent. I don't want to go further into that. You can do the investigation. So I can tell you that we are happy the way and manner the hearing ended. We are very ready to react to the addresses of the respondents, which they must file in the next 10 days from today. Thereafter, we will file our reply.